At what point does market leadership become a legal liability? In a global economy where technology shapes everyday life, companies can grow rapidly, influence billions of users, and control critical platforms. Yet the law asks whether such influence crosses the line from success into restricted competition. This is the question at the heart of United States versus Google LLC. Antitrust law in the United States exists to preserve competition. Is not designed to punish corporate success, but to ensure that markets remain open, innovative, and responsive to consumer needs. At the foundation of these laws is the Sherman Act, passed in 1890, which prohibits conduct that restrains trade or maintains monopoly power through unfair means. The Department of Justice, or DOJ, serves as the federal agency responsible for enforcing these laws, often working alongside state attorneys general to evaluate market practices. Google LLC, founded in 1998, is now one of the world's largest technology companies. It operates across multiple markets, including internet search, digital advertising, mobile operating systems, and data services. Unlike traditional industries, digital markets rely heavily on network effects, where value grows as more users participate, and default settings, such as pre-installed applications or search engines, can shape consumer behavior on a massive scale. The central issue before the court in this case involved agreements and contracts that secured default positions for Google's services. Specifically, the Department of Justice focused on arrangements in which Google's search engine was set as the default on browsers, smartphones, and other devices. Pre-installation agreements with device manufacturers were also scrutinized. These contracts, on their face, were legally permissible. The question before the court was whether the scope and effect of these agreements limited meaningful competition in search and digital advertising markets. Court filings show that the first major complaint was filed by the Department of Justice in October 2020. This lawsuit focused on Google's search engine and search advertising, alleging that the company's arrangements with device manufacturers and browser developers reinforced its market position. In January 2023, a separate case was filed by the DOJ targeting Google's operations in digital advertising technology, commonly referred to as ad tech. Trials in both cases involved detailed economic analysis, internal company communications, and assessments of market structure. Google has disputed the allegations in court filings and has indicated its intention to appeal certain rulings, maintaining that its practices reflect lawful competition. The primary question for the court was whether Google possesses monopoly power in specific markets, and if so, whether that power was maintained through conduct that could be considered anti-competitive under U.S. law. The court evaluated whether these arrangements had the practical effect of limiting competitive entry, raising barriers for other companies, or reducing consumer options. Both the DOJ and Google presented evidence, and the court assessed it with an emphasis on economic impact and market dynamics. While this case focuses on a single company, the implications extend across industries. Companies operating in technology, telecommunications, finance, and emerging digital sectors such as artificial intelligence now face heightened awareness. For executives and board members, compliance and risk management are increasingly central to corporate governance. Market leadership, while a sign of innovation and operational success, now invites closer regulatory attention, both domestically and internationally. Cases such as United States versus Google LLC are part of a broader trend. Parallel actions have been observed in cases involving Amazon, Apple, and Meta, demonstrating that the regulatory focus is not limited to one company. Analysts note that these developments reflect a regulatory era shift, from oversight of traditional products and services to the governance of digital platforms, ecosystems, and data flows. The outcome of United States versus Google LLC may not determine the future of a single company, but it will influence how governments, regulators, and courts define competition in the digital age. As observers, executives, and policymakers consider these developments, several questions remain open. How should competition be measured in platform economies? These are structural questions with implications for innovation, market access, and the design of digital ecosystems for years to come.